You are with me, Siobhan, and let's see, today is June 27th. We're almost done with the month already. It is flying by. I'm very excited today to welcome back guests that we were with just a few weeks ago, I guess it was. And I'm very happy to have both of these people in my life in the way that I do. I love getting on the air with them because I get to pick their brains and I get to probe into their experience, and it really helps me move along in my endeavors. So everybody, we're welcoming GTEN today, Global Trust Education Network. We're with Christian and PJ, and today we're going to be talking about two very important topics, right to travel and trust web structures. These are both topics, these are both webinars that if you become a member of GTEN, you will have access to. I'm a student myself, I'm a member, and it is one of the best educational resources that I have personally come by in my several years of studying this information. One of the things I like about GTEN very much is that they really just get to it. They don't waste time with hearsay or people's ideas about this information. They just find and provide the case law and the sources directly. They go directly to the sources and they make that available for their members. And so I'm really grateful for that because I've been getting the most out of that actually in my short time of visiting that than anything else thus far. So without further ado, welcome Christian and PJ to the Humanity Transcending show.
Greetings.
Thanks for having us on the show.
You got it, my friends. All right, so I know we're going to kind of just freehand about this conversation today. I do have some sort of questions just to kind of get us going, but let's definitely start with right to travel. As we had discussed, I think this is a very important topic because there's a whole movement, right, the so-called freedom movement or sovereignty movement, whatever you want to call it. It's morphed over time. But one of the things I think that people try or want to jump into right away, myself included, I did the same thing, was to jump into asserting a right to travel, but not really comprehending what that means or who they have to be in life and in their behaviors and actions and interactions to actually be able to stand on such a thing. I kind of jumped into asserting that right while still, having a license on me, while, still not really understanding what I was saying. And of course, I got myself into a little bit of trouble. I did something's wrong, something's right. But I think this is kind of a common experience with people who jump into this. They want to assert the right, but they have no real comprehension of what a right really even is, or they don't understand the basis or grounds for being able to stand on it, right? So let's start with this. I'm going to just express this, and I'm going to leave it both to you. I'm going to give the floor both to you and get your thoughts on this, okay? So I know you guys will, I'm sure, at some point bring in some of the case law to substantiate what you're going to be saying, but I had this thought earlier that, the reality is regardless of law enforcement policy officers, right, regardless of their ignorance of the law, regardless of our own ignorance of the law, these precedents and organic laws upon which everything rests are able to be invoked still. So even though it might look like a losing battle, in actuality, all that we need is here for us to stand on our right. So where are we falling short? Many people that I've come across just in forums, even chat forums and things like this, and are disappointed because they don't really believe it's possible, or they've tried to assert a right and it didn't go well for them. They didn't have success or the results they wanted, so they've just, said, well, this doesn't work. And like I said, myself included. But I really want lasting results in asserting my rights, and I think a lot of people would like that for themselves and living by my rights and not by privileges. So my question to both of you, which I think will lead us into a good conversation about this, is where are we falling short, and why do you think that is? Not you particularly, and when I say we, I just mean the general the folks who are involved in this movement for themselves to experience, freedom and assert that. Where are we falling short, and why do you think that is? And I just give the floor to both of you now.
Well, I have a short little answer that might start us talking, and I think it has to do a lot with what you had brought up just a moment ago, and that's that, the license, the registration, the insurance, these are all contracts, and a lot of individuals don't fully understand that they have consented to contracts that allow certain things to happen. And I think that's our biggest, fall short, as you were saying, is fully understanding the contracts that we are already in and consenting to, whether they're invisible or tangible, and being able to control our lives a little better after understanding those contracts. So that's, oftentimes when we're invoking those rights, what we fail to recognize is that we're already operating under presumption of law, under a consented contract that gives, for example, that officer the right to ask me what's going on. So I think that's where we fall short to begin with.
Okay, Christian?
Yeah, I mean, there's the law, and then there's the code, which is legislated. It comes from statute, and it is given the force of law, but it's not the same thing as the law. Think of it as a set of rules for society that have been legislated and contracted to. That doesn't mean that it necessarily overrides the law, but it certainly, if you contract into that arena, then you've agreed to play by those rules. And so, the situation we have in most countries, including the United States today, is that the code has sort of become everything, and the courts only look to the code and the statute for the most part, and the police are trained, in statute and code, not in constitutional rights, and by that I don't mean that rights are granted by the Constitution. When I say constitutional rights, what I really mean is those are inalienable rights that are protected by the Constitution. Okay, and so we get into this paradigm now where we're living under the code, the codified statutes, that is, and we've forgotten what our rights are. And if you look back at what our rights really are, I mean, they haven't gone anywhere. It's not like they've disappeared for some reason. We've just recontracted. And the truth is that licensing can't be required, because the act of taking on the restrictions of a driver's license requires the surrender of a right. So therefore, no amount of legislation can require us to contract that way and travel by the privilege of a driver's license instead of the right of personal liberty. But if we don't know how to stand on rights as opposed to privileges, then we get caught up in this kind of standard operating procedure that that'll get you every time if you don't know what you're doing. And I think the direct answer to your question, Siobhan, is that where people really get in trouble is they don't realize that the driver's license and registration and insurance all do that. They all drag you into the code. Okay, those three things bring you into the jurisdiction that is operated in statute. Okay, so if you have a registered car with insurance, but you don't have a driver's license, well, you're not playing by the rules. You're not, you've opted in with the registration of the car and the insurance, but you don't have the third component. Okay, or if you had a driver's license, but your car is unregistered or uninsured, either one, then you've got the contract with the driver's license, but you don't but you don't have insurance. So therefore, you're in contract, but you're breaking the contract. So I think the important thing to understand is that those all work together, and where people get into trouble is that they don't realize that. I mean, even just insurance, and I'm not suggesting that you shouldn't have some form of financial responsibility backing what you do in life. There are ways of doing it without.
Would that be like a private monetary instrument, like a bond or a promissory note to back?
A private bond could do it if you were traveling without a license or registration. Mm-hmm. That private bond would do it. But you need to understand that they all work together. That you need to have basically all or none of those three things, because the reason I mention insurance is that even if you were a private trustee of a private trust, operating or managing trust property, that is the car for the trust, but you had the car, you had a contract with a U.S. corporation, an insurance company, and that U.S. corporation, may not be a contract with the state, but it is entering, your private trust is then entered into the jurisdiction by doing business with that corporation, mm-hmm. and therefore you're now in the jurisdiction. So understanding that, these three things, license, registration, insurance, they run together. If you're going to play under the code and do it as the code, rules designate, then you need all three. And you're going to get in trouble if you don't have all three. And if you're going to stand on rights, then you need to substitute each of the three of those with something viable. Okay, mm-hmm. You still need to be responsible on the road. You still need to be insured, but you shouldn't do it through Allstate. Okay, because in doing so, now you're in the jurisdiction. You're in the federal jurisdiction, and the states and federal government can apply the code. Okay.
So you would do it. So you would do it through then a trust, like you would have the trust issue you a license, right? And you'd have the trust. You'd have the car maybe registered or accounted for with the trust.
These are viable.
Well, that's.
Yeah,
that's the way of doing it. That is a way.
Yeah, that's exactly right. These are viable replacements if, fully understanding what it is that you're doing. These can prove to be viable replacements for contracts that are, known as bilateral or trilateral contracts, contracts such as the license, the registration, and the insurance. And, we focus on providing, viable options outside mm-hmm. of those. But we have to understand where they were started too. I mean, historically, we are the ones that have requested and consented to these contracts. The license was a request historically from the creator of Mercedes-Benz, to travel in his motor wagon, and it was a battle between his right to travel in his new motor wagon that he created and the right of the people to be peaceful in their public, because the vessel was making a huge amount of noise and was making smoke. And so he requested a permission slip from, I believe it was the Grand Ducal, allowing him to operate that motor wagon. So it was by request that he had asked for a permission slip based on reflecting his rights. The insurance is a very similar thing. We're looking for some form of liability to ensure that if there is some sort of accident, that property is protected. And that's where the bond came from. The registration is a very similar item, where there needed to be some form of regulation, some form of census to ensure what's happening, some sort of record of all of these established vehicles, or, well, in the state, yes, vehicles. And so the state has developed a system that registers these cars as a portion of their property, giving them basically trusteeship of the vehicle, giving them legal title, splitting the title, giving you beneficial title, which allows them to have jurisdiction over that car, over those roads. And since you've applied in a commercial form, they consider that somewhat of a commercial action. And historically, the roads were not going to be, no one using those roads were going to be taxed unless it was for commercial use. The private use of roadways was, for the purpose of private individuals, private citizens at the time.
So that's good to touch on, because somebody just mentioned on one of these chat boxes, I can't keep up with which one, but it says the legal problem I always crashed into was, yes, you can travel all you want, but if you want to travel on a state-owned road, then you have to follow the state-maintained rules. But you're saying the organic laws and case law actually points out that the roads are for private individuals.
Yes, and not for commercial use, and the only time that one would be taxed is if it was for commercial use. So, I don't have the.
So they have no basis for asserting that claim at all. That if you want to travel on a state-owned road, then you have to follow, state rules. They have no basis for that.
That's questionable. We believe, I feel that the basis would be the presumption of law by applying for a license to operate on those roads. So
with the exception of that.
With the exception of that, well, that's kind of where we stand. But ultimately, there's this overlaying blanket of understanding where without a license you can't, drive, quote unquote, on the roads. And
this is not true, right?
These are all codification words. All the words I'm using all have distinct definitions within the code. Travel as opposed to drive, operate as opposed to, manage. I mean, all of these are, codified words. And so we've gone through a handful of the definitions of these words so that we can distinguish codification words from words that represent, I guess you could say, our natural right to travel. And we distinguish those because the code gives specific definitions for the words that they use, and we operate through those definitions, through those contracts. And oftentimes we don't recognize that there's an ability to operate outside of those contracts as well. We've converted that right for a privilege to some extent, right. and unknowingly.
So this would be part of the problem, is that the language that is being spoken in the code is not what the majority of people think it is, and so we're involving ourselves into all sorts of adhesion contracts because we don't really understand what's being said. I did look at that on the site, just as in part of me doing my homework, just scrolling through, and I saw that you all differentiated between language of the code and language of the law, I think is the other title. And so tell us a little bit about that. I mean, I know legalese in a way is like speaking an entirely other language, like speaking Chinese or something. It's really that different from just regular, everyday, common speaking. So tell us a little bit about the differentiations between what language one wants to be speaking when asserting their right to travel. We already went over that you can't have a license, a registration, and insurance as status quo would have you have it, because that places you then. I mean, you could if you wanted to, but in the context of what we're talking about, doing that places you under the control and jurisdiction now of that entity of the corporate government. So what should people be looking out for?
Well, just as a definition, and I know Christian has a great answer to this, but just as a definition of what you're talking about, to understand the difference between the code or the language of the code and the language of the law is just to understand that contracts have the ability to define terms in their own contract, and within that contract, the term that is defined in that way means that thing. So, for example, Christian's dealt with a lot of mortgages. When you see the definition of lender, they have a specific phrase or verbiage for the definition of what the word lender means in that contract. And we have to kind of look at it like this. Like, let's say that this is a contract and they have placed specific definitions in their law, in their contract, and we are abiding by those as opposed to some of the definitions that just exist, say, in Webster's or in Black's Law. So we're talking a codified language rather than legalese or even regular English. It's a codified language that is is created by way of understanding the definitions within the contract, because any contract, just like a trust, definitions can be made, terms can be used, and they can mean whatever you want them to mean. Blue can mean orange if you want. So you have to be very clear as to how they're being defined to understand the difference between codification words or words that are being used in certain other circumstances. So I hope that just to give a base clarification.
That's perfect. Yeah, like PJ said, the lender in a mortgage or a deed of trust is defined as Bank of America or Wells Fargo, even though they didn't loan you anything, right? So you have to realize that this is happening, and it's the difference between the definition of a word, or therefore the meaning of a word, and a term. So if you define a term within a contract, you're no longer dealing with the meaning of the word. You're now dealing with the term as defined. And there's a whole list of them. Like the language specific stuff to the code or legalese is driver, license, vehicle, motor vehicle, passenger, baggage, transport, transportation, operator, carrier, goods, merchandise, chattels, commercial. All of those words are language specific to the code. And the replacements for those are car, which is a consumer good, automobile, conveyance, travel, guests, property, non-commercial, and private. Okay, and if you're going to talk about this stuff, you want to talk about it in those terms. I think it would be actually really valuable to for those who are really skeptical about any of this, to read a few pieces here, if they give me a moment.
It's amazing what they'll read, right?
Somebody's coming through that. I don't know who that is. Can you mute your mic, please?
Okay. So personal liberty. This is from Corpus Juris Secundum. Okay, a compilation of active law. Okay, personal liberty, or the right to enjoyment of life and liberty, is one of the fundamental or natural rights, which has been protected by its inclusion as a guarantee in the various constitutions, which is not derived from or dependent on the U.S. Constitution, which may not be submitted to a vote and may not depend on the outcome of an election. It is one of the most sacred and valuable rights, as sacred as the right to private property, and is regarded as inalienable. That's 16 Corpus Juris Secundum, Constitutional Law, Section 202, page 987. Now, that's talking about personal liberty. Now, bear in mind that personal liberty includes the idea of locomotion. If you look up personal liberty in Black's, personal liberty consists of the power of locomotion, of changing situations, of removing one's person to whatever place one's inclination may direct, without imprisonment or restraint, unless by due process of law. And I'll read one more here, American jurisprudence. Personal liberty largely consists of the right of locomotion to go where and when one pleases, only so far restrained as the rights of others may make it necessary for the welfare of all other citizens. The right of the citizen to travel upon the public highways and to transport his property thereon by horse-drawn carriage, wagon, or automobile is not a mere privilege which may be permitted or prohibited at will, but the common right which he has under his right to life, liberty, and the pursuit of happiness. Under this constitutional guarantee, one may therefore, under normal conditions, travel at his inclination along the public highways or in the public places, and while conducting himself in an orderly and decent manner, neither interfering with nor disturbing another's rights, he will be protected not only in his person, but in his safe conduct. That's American Jurisprudence, the First, Constitutional Law, Section 329, page 1135.
Now, where did that change? Where did that all of a sudden start to change? Well, I believe, I propose that we see a some sort of difference there between private for the use of the public roadways and public for the use of public roadways. So there must have been some form of application to apply, use the public roadways for commercial use. And I would be willing to bet that in doing so, a car had to be registered to ensure that it was being, mapped and making sure that it was meeting all of the requirements of taxation. So, I don't know about you guys, but I've run into the issue where, trying to invoke this while traveling, the individual or the officer will say something to the effect of, well, you're welcome to travel anywhere you like, and I'm not going to impede your traveling or your right to locomotion, so long as you're not using a public roadway in a public transportation vehicle or a commercial vehicle on the roadway. So he'll tell you that you can travel, right, but you're not supposed to be using a car to travel, and that doesn't cover it. Well, we just read clearly that automobile is covered under there. So where did they get the opportunity to say, I'm sorry, we can't? Well, it's by consent, is it not? When we register these vehicles, we give them a right to, the property basically becomes ward of the state. And they give us permission by way of their corporation on how we're going to use that property. It's a trust. We've donated property as an exchanger to the trust, and we've exchanged that property for a beneficial interest certificate and a usufruct on the property. Yeah. We at one time owned the property with a manufacturer's statement of origin showing that it had transferred from one owner, the manufacturer, to the new owner, the purchaser. Mm-hmm. But for some reason, the state requires that manufacturer's statement of origin gets placed into the Department of Motor Vehicles, and in exchange, they issue a title, a certificate of title even. Why is that?
In a way, they have the original title, right? So they keep the original, that first chain of transaction, that first link from the manufacturer to the dealer.
So who's the real purchaser?
That's the one the state takes, and then the state then issues a title, but now that it's state issued, it's controlled by the state, right? So
would that officer be able to say anything to you if he didn't have some form of contract that formed a presumption of law to allow him jurisdiction over that car?
Yes. And that's what they look for. They're looking for the jurisdiction, right? So if there's registration, if there's a license, if there's,
If there's a license plate on there, if it's been registered, they immediately have it. And now they have the right to stop you to see if you are within all of the bounds of the rights of the code or of the enforcement of the code, whether or not you have your insurance, whether or not it's a legitimate insurance bond that's backed by a corporation that is a charter of the state by which you are having your car registered, which is a requirement of the state that has your car registered. Whether you have a state-issued license by their state. If you have it from another state, they'll force you to get one in their state within 30 days if you're a resident. So they're very serious about maintaining some form of control over the property that is within their state. Why? Because it's valuable property. It's an asset. It derives revenue when you break the rules from its use. It's a very interesting system, and we've all consented to it by way of application, thinking that we need to apply for something that we already have a right to do naturally.
Well, let me play devil's advocate here, and just a quick announcement, everybody. I'm taking questions for PJ and Christian, like the last 15, 20 minutes of the show, only because there's a lot of just really wonderful material that I want to come through over the air first. So we'll reserve questions for later so that we can cover as much as we can. So let me just play, the other side here. And so let's say that one did want to now, disengage and cancel those contracts that they've made, and they want to now exercise their right to travel and live according to that and to those set of rules. But let's say, something I hear sometimes is, these judges make up their own rules. They don't care about law. They'll throw you in jail, even if you try to challenge them. So what are the obligations of the courts and the judges with respect to the organic laws and, natural rights, and even constitutional law? Like, how does one get there? New status that they're asserting, that they're living, to be recognized by the courts and the judges. right? Because the skeptic mind is like, well, they don't care. They'll just railroad right over you. You don't care what you say, So, but I believe that's only because we're missing key elements to our, I don't want to say argument. I don't mean argument in the sense of like a debtor argument, but in our asserting ourselves and expressing our position. How does that get recognized?
Well, I don't know if you're going to follow this, but in an Article 1 tax court, a legislative court, the Constitution doesn't apply. That's why it feels like everybody's so butthurt about how they're making up their own rules and they're not paying attention to the Constitution.
That's a court of code, then? Would you say the Article 1 court is like a court of the code and commerce and contract?
It's a legislative tribunal. It's a tribunal that determines political affairs, and it's a violation of the separation of powers for the judiciary to involve themselves in any decisions being made by an Article 1 court.
They can't even hear that stuff, I guess, right? They can't even hear a constitutional argument or a natural rights argument.
It's a violation of the separation of powers.
Wow.
If you're looking for a constitutional argument, then you can bring the validity of the constitutional argument to the judiciary. But since the 13th and 14th Amendment and the usurpation of the Congress and the fact that we don't have that action that separated our Congress and attempted to enforce legislation, not judicial, but enforce legislation by ensuring that all states stay within the Union and handle their debts, they went by force, by military force, by martial law to enforce legislation to ensure that was going to happen. They sidestepped the Constitution because that action, the 13th and 14th Amendment, and I say both of them because it's a little early, I can't remember which one specifically, but the actions that took place in there stripped private property from individuals without due process, which is a violation of the Constitution, and the judiciary could not do anything about it because it was under martial law at the time that it happened, and the courts that were enacted at that time were legislative courts from there on that could handle the political affairs of the legislation and had nothing to do with the constitutionality of the action because we've been under martial law since.
Right. Okay. Wow. All right. Christian, can you expand on this a little bit by talking about then what an Article 3 court is?
Sure. I mean, the key is to understand what arena you're playing in, and there are two. There's Article 1 and Article 3, and the one good thing about the legislative tribunals, Article 1 courts, and everything that circles around that, the police officers and how they do their job, and the tickets, the traffic citations, and all of that, is that these courts all fall under admiralty. They're all commercial. Everything that happens within them is commercial paper. And if you understand that, well, then you play that a particular way. For example, when you're handed a traffic citation, well, it's a commercial presentment. It's an offer. You have 72 hours according to the Uniform Commercial Code to accept or refuse that for cause. So, if someone with a badge hands me a ticket, I send it back to them. Refused for cause, signed and dated with a letter. And then that's it. That's all I do with it. That's the end of it. Because they presented me with everything that they can within the rules of that jurisdiction. And all they can do is present me with a commercial presentment. It's not anything I need to treat as anything other than commercial paper. So I refuse that for cause and have a nice day.
Okay.
So, understanding what arena you're in is important. Now, if you're falsely imprisoned and, your rights are violated by that officer or anyone, then you want to bring an action if you're so inclined in an Article 3 court, because you want it to be concerned with rights, not commercial paper. So, when you summon an Article 3 court, you're standing on your inalienable rights protected by the Constitution, and you really don't care about their code. So, understanding the distinction, the difference, and how to stand on rights versus privileges. That which arena am I in right now, and how do I need to behave in order to get the result that I want?
Okay. So is there an arena that distinguishes between the unalienable rights versus inalienable rights? Is an Article 3 court just operating constitutionally, or you see what I'm saying?
Okay, so unalienable rights are God-given. Okay, they are natural rights. They're divine law. Your rights under divine law and laws of nature. And our Declaration of Independence talked about unalienable rights. But when we got to the Constitution and the government was looking for some control again, those were sort of converted to inalienable in the way we talk about them. So if you want to stand in the courts, even in Article 3, you're really talking about standing on inalienable rights, which is good enough. The distinction we've talked about on a previous show, for those who didn't hear it, the distinction is very fine, but also kind of important. And
I have a good example of a distinction too.
Go ahead.
Just to be clear, like a distinction of the unalienable right to contract. When you've been in prison, you still have the power to contract at any given time. Even attempting to contract away, right, to consent to contract away your right to contract is in effect contracting, and is literally an unalienable right that in no way could ever be taken from you. An inalienable right could be a right to freedom, where you have forcefully had your rights taken from you. An inalienable right is a right that is inherent, that is natural, but in some ways could be taken from you by force. Your right to freedom, you could be imprisoned by force, although within that prison you have the unalienable right to contract. Is that?
Yeah, okay.
Give you kind of an understanding of there are now the inalienable right to freedom of movement, freedom of personal liberty, all of that is real. But that doesn't mean that there haven't been usurping military governments that have taken that inalienable right from someone. Are they able to take the unalienable right to contract? Absolutely impossible, because you would have to cut out their tongue or take away their ability to write or take away their ability to cognitively understand what is going on and nod their head yes or no. Mm-hmm. So, I mean, there's a real depth of unalienable right that comes from the right to contract. Okay.
Yeah.
And even then, someone with their eyes could still contract a yes or no, an agreement or a denial or rejection. So these things are, that's how I see it. That's just my personal opinion.
That's the God-given, that's just like inherent, like self-evident, just something,
We've been given the right to move, but there are ways to physically inhibit movement. There are certain rights that are completely unalienable, but can be, what we try and distinguish as inalienable. And I think the difference in that was the difference between, wasn't it the Articles of Confederation and the Declaration, Christian, or was it the Declaration and the Constitution?
Well, the Declaration of Independence, we were looking to break away from the king, right?
Yeah.
And so the Declaration, what a great time to stand on God's laws. Mm-hmm. and our unalienable rights.
No contract.
And it felt good at that point to just say, we're going to operate on nature's laws here, and we're going to claim these rights. Okay. And then, when it came around to the Constitution,
it's time for a little more control of
government trying to govern over people again.
Yeah,
and
so
they're like, enough of this unalienable rights shit.
Interesting, right? We need
let's implement some control.
Yeah, we need to let them know that they have rights, but there is a social contract that they are entering into that may change the definition of what God-given rights are based on their social acceptance of this contract. So the sovereign is now giving power by way of a social contract, and there is a balance there. In fact, the book, The Social Contract, completely covers that. It's a really great book.
So when then, like you say, Christian, just needs to know what arena they're playing in. Really is all it is, to comprehend, various law forms so that you can implement or, execute procedure for either one, depending on what the situation calls for. Like you're saying, the Declaration of Independence. Well, that was a time, yes, to stand on those rights. You might not have to, like you said, if you're dealing with a traffic ticket, you just send it in within the 72 hours and refuse it for cause with the letter. So, yeah, this is giving some ease, I think, to it.
Well, Siobhan, what you're just saying about the contract with the ticket and what Christian was talking about simply sending something refused for cause. Well, he knows exactly where he's operating from when he does that. He's not just saying, I got a ticket and I gave my license, I gave my registration, my insurance, and now I'm going to refuse for cause this ticket that they totally had a right to write me because I consented to their authority and showed them that they had a full jurisdiction over my person. Now, when he says something like that, he left out something pretty big. And that's that he's operating from a certain spot that he understands completely. He understands what jurisdiction he's operating from. He understands what contracts are in, fluent movement at the time. And he understands where he's going to present himself. He may have presented himself in a car with a manufacturer's statement of origin placed in trust, with a bond that's been issued by a public holding trust, and a permit or a license to move that property as he sees fit as trustee of that private trust. And that officer may have said, I don't buy it. No registration, no insurance, no license. Here's your ticket. And he may send back refuse for cause because they just impeded on commerce under private law, private international law. They don't have a right of jurisdiction to impede commerce under another jurisdiction. But if we were operating under their jurisdiction, they would have all the right in the world to cite and charge Christian with some form of traffic incident. But because they could be held liable for impeding on
another's jurisdiction.
Most definitely. They just encumbered property that has a priority security interest lien against it, and the individual that is the security interest holder is going to place in some form of dismissal or some form of notice of interest, ensuring that property cannot be charged in that jurisdiction because they have no right to contract with it. So, when he says something,
connected.
Yeah, when he says something,
you said so much right there.
When he says something as simple as refuse for cause, I wanted to kind of touch on that. But that's the reality of it: is where are you operating from before you say to yourself, refuse for cause. I think that's what a lot of the individuals speaking about this stuff happen to leave out, and this is something that we as a team, try really hard to disseminate clearly, by way of using case law, by way of using historical law, and understanding, current procedures as they stand. And when we can deliver this information, it is absolutely invaluable to those that are getting it. You will see things a different way, and every contract, every stop, everything that happens from here on out with your car, your license, and everything that goes on, you'll think twice about, believe me.
Yeah. Christian, you were going to jump in there too.
I'm really glad you clarified that, because you're right. I mean, the risk of listening to this radio show and then going out and trying this at home is quite high. There's a learning curve to everything we're talking about, and a little knowledge is definitely a dangerous thing in the approach on this. Is Siobhan, it sounds like you found out. And lots of people do. They get a little knowledge on this subject. They say, what the heck, I'm going to try it. I'm going to stand on my rights. And
it all goes to hell pretty quickly.
Yeah. So then that's why we decided to put together a webinar series on the topic. I mean, that's why at GTEN.org, that's why we have the Right to Travel webinar series. and it really gets into it. I mean, we don't recommend anything, but we do dig into, where the law falls, depending on how you're operating and where your rights are, where they're hidden in plain sight for you to find, and what it looks like if you choose to operate on rights rather than privileges.
Yeah, one of the guys that's been operating this way for a decade, and I don't recommend you do what he did. I don't recommend you do what he does. But I do, maybe think you should take a look and see if you wanted an example of somebody who is operating this way. His name is Charlie Sprinkle. He's got YouTube videos and stuff, and he's been operating this way for the last decade in the state of California, and he's gone through some court procedures to do it. There are people that are operating in this way successfully. There are some results that we see, but they are few and far between, and most of the reasons why is because of the topic we just covered, which is you get a little bit of information, you get all enthusiastic, you're like, of course, I see this case law, this makes sense. What they just said makes perfect sense to me. Go out there, you try your run, the officer slams you up against your hood, and everybody's like, oh, those guys were full of crap. So
right, that's pretty much it in a nutshell.
Yeah, and so you have to look past that. You have to be prepared to do your due diligence, and you really have to do your research before you really attempt these things. And ultimately, attempting them, if you let's put it this way: if you attempt this and it goes perfect, you get no flack and you get no recognition. I personally feel you might have done something wrong. You might have slipped through the cracks. If you're getting some sort of resistance, or you're getting some sort of acceptance, acknowledgeable acceptance, you are making progress, okay? One or the other. You're either going to get a negative or positive response. If you don't get a response, that means they probably ignored your stuff, and don't use that as a form of, positive reinforcement, like, oh, they didn't respond, I must be doing great. So, look for some form of response in these things, whether negative or positive, to know that you're getting some form of acknowledgement, some sort of interaction between whomever it is that you're looking to operate with, whether it's sending something out to the DMV, whether it's operating right there with the officer, whether it's operating with a judge, something like that. When we've gone into court procedures, the judge will, albeit very small situations, he'll recognize certain things that we've done, which is, that's what we're looking for. Is we're looking for progress that is, measurable.
Mm-hmm. Yeah, real results. Absolutely.
Real results. Good or bad, because success is relative.
Well, I prefer the good results, but yes, the bad results are, they're part of it too.
How much more have you learned from the bad results that you've gone through than the good ones?
That's a good point. Christian, go ahead.
Once the exercise here really is get a vast body of knowledge, under your belt, and then, figure out how that works. And then, you have a mirror, right, at home. I assume you have a mirror in your bathroom or your bedroom. Mm-hmm. Practice speaking in a way that puts forth that knowledge with respect, love, peace, compassion. Get the truth across in a way that doesn't make you look above the law or indignant or dismissive or any of that stuff. So part of this is getting the understanding, and part of it is really learning to speak with people on a level that gives and demands respect at the same time, and it comes down to, so much of this comes down to whether the police officer is, which is the first line of contact, right? How's that going to go on the roadside? And is that police officer going to be inclined to throw you in jail, or and impound your car? Or is that police officer going to find what you're saying, to be more than he knows, and yet said very respectfully and with love and compassion and peace, and more often than not, the way you handle yourself controls your immediate future.
And you may have sold him on it. In fact, he may actually go home and take a good look at what you were saying, And just to segue into what you're talking about right now, Christian, and this is something that we cover big time in this course, is your come from. Dharma. It starts with Dharma. It starts with understanding where you're operating from and what you represent as being important in this life,
This is a good point. This is a good point because I think a lot of people, like, the default emotion is maybe anger or fear. And so in that fear or in that anger, your come from and your delivery may be just completely off. I'd say put the officer on a defensive stance, and not feeling too sure about you and what you're doing. So I think this is a really good point you bring up because I think, spiritually, people know we need to do that in our relationships, but I think bringing it into this it's necessary because it's still us creating. It's still us creating and infusing the energy, and the outcome is going to reflect that. So, we have to do that even in here and speaking with, policy enforcers and the like.
And I don't know if Christian agrees with me, but I would say about 30%, maybe 30%, maybe a little less, is really about the mechanics, the codification, the definitions, and the knowledge, quote unquote, in terms of law or finance that you're going to take away with you. The other 70% is your understanding of how you're operating with this knowledge, your understanding of what your effects are when you act in public, how your actions affect others, and how conscious you are of your actions, because that, I believe, is where most people fail more than ever. And so we take a lot of time to focus on where your understanding is and where your come from is, and if you're going to operate in a positive way, where you are actually enrolling that officer in what you're saying. You're saying to yourself, this is some of the stuff that I've been studying, and these case laws are unbelievable. And, on a personal level, sir, I'd love for you to take a look at the stuff and let me know if I'm crazy, because I'm at a crossroads right now. So it's about your come from, and it's about how you approach this. The definition of Dharma is the law that upholds, supports, and maintains the regulatory order of the universe. But we are always affecting that regulatory order of the universe, and as we know, our consciousness is raising, the paradigm is shifting, we are becoming more responsible for our actions, we are becoming more loving, more compassionate, and it's these things that we need to reflect in our everyday life, even when operating in this knowledge that is going to be the game changer from what was once a patriot or a creditor to now someone who is a knowledgeable, responsible trustee of their life.
Yeah, beautifully said. Beautifully said. I know we will be coming up on the break shortly, and everybody stay tuned. We're going to be jumping into trust web structures, another offering from GTEN's many wonderful webinars and online seminars, and I encourage you to visit their site, gten.org. And you can visit me at humanitytranscending.com. Anything you guys want to say before the break, it should probably come in about a minute or two. So, anything you want to wrap up on right to travel. And then when you hear the music, I'll just take us to break. But say what you'd like to say.
I'll just add in that California, at least, under Penal Code Section 19.7 says, except as otherwise provided by law, all provisions of the law relating to misdemeanors shall apply to infractions, including but not limited to powers of peace officers, jurisdiction of courts, periods for commencing action, etc. So these infractions have the same standards as any other.
Global Trust Education Network today. Christian and PJ have joined us, and the first hour was just awesome. It's so rich. I can't wait to go back and listen to it after it's archived. You guys just hit on so many golden nuggets, so I know there's just going to be so much when I go back. Christian, you wanted to finish up an important thought. Could you repeat what you read and then complete your thought, because I'd like to hear it, and everybody else too.
Surely. Yeah, apologize for that. I thought we had minutes left, and it turns out we had seconds left before the break, and this is too much to cram in there. So let me read this again.
That was my bad. Bad host. Bad host.
No, I was just looking at the clock. And anyway, in California, and I believe this must exist in every state. Okay, I haven't found it elsewhere, but in California, Penal Code Section 19.7, application of provisions of law to infractions. Okay, now the reason I'm going to read this is that if you go into court and you try to stand on a typical defense to a traffic ticket, but the judge will typically say, well, this is traffic court, that doesn't apply, or this is an infraction, not a misdemeanor or a felony. Okay, now keep that in mind, because it's dismissed in the same way as we were talking about earlier, where people travel on the road in a car and they say, well, if you're using the public highways, then you got to play by our rules. Mm-hmm. Well, these things just aren't true, and here it is in the California Penal Code. 19.7, except as otherwise by law, all provisions of law relating to misdemeanors shall apply to infractions, including, but not limited to, powers of police officers, jurisdiction of courts, periods for commencing action and for bringing a case to trial, and burden of proof. In other words, if they can't prove that ticket, it's nothing. The fact that the fact that they've issued it doesn't put it in some class of infractions that have different, it's just not there. If you're standing in the right place when you go into court and you know who you are and what your rights are, and you're in there to talk about a ticket, that infraction doesn't have special rules. The burden of proof is the same as if they were trying to charge you with a misdemeanor.
Say that again. I'm sorry. I was getting distracted because there was some feedback coming in from the caller, just like the last two sentences you said.
Well, the way the peace officers operate, the way the courts operate, and the burden of proof are all the same as if it's a misdemeanor. It's right there in the California Code that they can't make this special traffic category. They get this infraction. That's so much is dismissed in courts as it's just an infraction. But the fact is, the rules for burden of proof still apply. Mm-hmm. And so then you get into, well, where's the body of the crime? Where's the injured party? Okay?
Right, and they'd have to produce an injured party, which is just where they really can't, because there is none, right? Like there literally is none. Who's the party? It's a fictitious company. It's a corporation, right?
Right. You get into the corpus delicti, the body or elements of the crime. Okay, and in every criminal trial, the prosecution must prove the corpus delicti, and the body of the crime itself. That is the injury, loss, or harm. Okay, and the criminal agency as its cause. And if you don't have those things, then there's no crime. Well, what the judge says, well, we don't need those things because it's an infraction. Well, okay, then why does the code say that the burden of proof and all other provisions of law relating to misdemeanors apply to infractions?
Right. So don't believe what they say just because they say it.
Right.
They could be telling you something completely wrong and erroneous.
They're in the business of revenue collection, and knowing where you stand is priceless.
Yeah. In fact, that's the only way you could ever get it to work for yourself.
That's right.
That's why our members love us so much, because they benefit so much from the things that we do. So, by the way, we wanted to offer some listeners here a little access to our site. We were wondering if you were interested in announcing that a little bit. So I believe we have a link available to offer a little bit of free membership to those of us that are listening today.
Very exciting. Tell us about it.
Well, we have a great little members portal that houses our red library full of our archives of documentation, lots and lots, hundreds and hundreds of documents in there, as well as, within that members portal is access to all of our videos and all of our homework materials and references and research materials that we use to help our members succeed. Now, what we've developed is we've developed kind of a peephole, I guess you could say. So you could take a good look through and take a look through our member portal and see what it is that we offer. It's a basic membership that we normally offer. It gives you full access to all of our materials with the exception of our webinar series. And then you have the option to sign up individually or as an entire package to gain access or register for those webinars. But we wanted to give a little free access to those that are interested in what we're doing. So, Christian, do you have the link available? I don't have the link available, but what we're going to do is we're going to put up a link for you guys in the chat and announce the link here. You just go ahead and type in that link and put in your information. You're going to receive a free basic membership to GTEN.org. You can take a good look at everything that we do at no additional donation and see if this is something that interests you. And you'll have access to a lot of the right to travel reference documentation that we've been talking about here, some case law, some great documents that will give you some really good background and help solidify what we're talking about here so you don't think we're just full of BS.
Excellent, and that's very generous.
No worries.
Right, the website is GTEN.org. That's GTEN.org. And the link for Humanity Transcending listeners, this is specifically for you guys. We created it for this show. That gives you free basic membership, which usually is $18. But the link for that is GTEN.org/library/HT. That's HT for Humanity Transcending. So GTEN.org.
If you can drop that in the Skype chat box, then I'll put it out onto the Revolution Radio chat room.
That's great.
As well.
Okay.
If you could do
I
that.
already did once. I will do it again.
Yeah, and then go ahead and repeat that.
You guys have to be quiet in order for me to repeat it. Okay. GTEN. No, you're doing it again. GTEN.org/library/HT, as in Humanity Transcending.
Thanks for bearing with us, Christian.
Okay.
We're always so excited about this stuff. We're always jumping around, so it's great. Yeah, and then of course, if you guys, if you want to take a little taste, if you get in there and you're really enjoying that and you want to get a little taste of the videos, but you're not ready yet, you can always go to YouTube and check out our YouTube channel too. So, but moving on. So,
well, great. So now let's see, it's 10 after the top of the hour. So let's dive into trust web structures. This is a upcoming webinar. Yes.
Okay. Yes, it is, and I'll go ahead and do a little introduction on this. The private trust education series that we have, really covers the extensive understanding of how to operate as a trustee, how to administer a trust, and how to create and facilitate trust and trust duties. What we started to run into issues of is that we did not clarify often how these trusts, these private express trusts, private of U.S. jurisdiction, private of state jurisdiction, operating as a private person or not even a person, as a natural person is the best way to describe it. How are they going to interact with the public without immediately availing themselves to the jurisdiction of the public? And there's a term that is often thrown around known as arm's length distance. And arm's length distance is the idea that one maintains no direct liability to an action, ensuring that they limit or completely alleviate their liability from any circumstance. So what we've found is that there needs to be pass-through entities that exist between the private trusts and the public companies to allow an arm's length distance relationship to exist. The Trust Web Structure series is going to discuss and outline 4 or 5 different scenarios with which a private trust could be used to interact by way of a pass-through entity or a special purpose vehicle, and then allow a form of influence and control into the public, and also allow a certain set of funds to be able to be returned back privately as perhaps not a taxable income or a non-taxable income. And of course, the difference between a taxable income and a non-taxable income is whether or not it's taxable. I hate to say that. It sounds kind of foolish, but once you determine the difference between a taxable income and a regular income, you would the distinguishing factor between those would probably have to do with the contract that you're operating under, right?
So these are ways that you're introducing and showing ways that the private trust can be actually kept private, so that it doesn't make a mistake and avail itself to another jurisdiction that it doesn't want to be governed by.
Exactly. That's exactly right. There's a couple of steps that one would, could easily make if not paying attention to what they're doing, that could easily avail what was once.
What's an example or two?
Well, going and getting a bank account with your private express trust.
Right.
You know what I mean? Some people will argue that a non-interest-bearing checking account is not is a private account, but let's be realistic here. You are forming a contract with an organization that is chartered from the state. Okay, the entire the whole distinction of private trust education is to let you understand the difference between a private trust that is an express trust that's created under common law by way of private contract, and a charter that has been issued by a state. Those are two completely different entities, and the difference between them is that there is an interest that the state has in one, and no interest that anyone has other than the private contract holders in the other. So when we go to contract between the bank that is a charter and the private trust that is private, that contract created between the two avails that trust to the jurisdiction that that bank is operating under, and avails that trust to being sued or suing that bank under that contract, because that contract between the two is governed under state law. And that is what avails that private trust to that jurisdiction. And anybody can pierce the veil of that trust because of that contract. There needs to be an arm's length distance between those two things.
Very clear. Christian, can you add something to that?
Well, it's just like the contracts we were talking about in the first half of the show. If you have a driver's license, then you've entered jurisdiction. Okay, but if you don't have a driver's license or a registered car, and you're not doing business with an insurance company that's a public corporation under the United States, then there is no presumption of law that any jurisdiction exists. And when you're talking about a private express trust, unless you operate, if you set up this private express trust outside of federal jurisdiction and state jurisdiction, and if that trust then operates in such a way that it doesn't tread on that jurisdiction, it doesn't directly do business in that jurisdiction, then there is no presumption of law that trust is in that jurisdiction. And it becomes, if someone were to sue the trust or attack the trust, it becomes their obligation to show the minimum contacts that brings that trust into the jurisdiction. And so, good luck doing that. If you've operated the trust in such a way that it has not entered the federal forum jurisdiction, then how is anyone going to prove that it has? Mm-hmm. And so trust web structures come about when you want to, operate from that position in the private, and you want to reach out into the public. You want to be able to do things in the public. I mean, the trust wants to be able to, have cars and real estate and transact business and whatever, but it's not, the master trust isn't going to do that, because the master trust is going to stay entirely private. But it still needs to bank and do business and all that. So that now there's a web of trusts created to connect that private position to the public, and it's the right way of doing it from that position in the private through special purpose vehicles and trusts and whatnot out to, you can have for-profit corporations, you can have charitable organizations and nonprofits, whatever, out as the public face, while the individual remains completely private as trustee of private trust.
Okay, that's also very clear. I just had a question and it left me. Actually, okay, here it is. I've heard you say in your videos that you're not reinventing the wheel. That these structures have been in place for a very, very long time. So can you share a little bit about where you get your information for this? Where what are you grounded in as far as sources that you've been able to piece this together and get that setting it up that way keeps the private trust private, and you can still interact at an arm's length with the public.
Well, I think the first basic source that you're going to find historically to see that people have been pointing to this is the quote by John D. Rockefeller. It's, the secret to success is to own nothing but control everything. Okay. Trust law has been well-founded. English trust law and equity is one of the oldest historical bodies of law there is. And understanding that no one needs to even be informed that a trust exists, even if they are a beneficiary or of that trust, is something to really pay close attention to, right? So are we going to find a lot of information about how private people have been keeping their wealth private? It's probably going to be one of the most difficult things to find, okay? It's probably going to be one of the most difficult things to find because it's a private contract between two individuals outside of any charter, outside of any state legislation, or outside of any jurisdiction of any country. Because we recognize under trust law that there is the land and there is the contract. That is it. There is the people and the contract. There's nothing more. But thereafter that, we start to develop different codifications and things of that such. So it's the case law, the information that we're going to be covering. There's not a huge amount of case law other than certain organizations that have been dissected and tried to have been found out. But the reality of this is that we are looking at basic financial structures that have existed throughout the last 100 years that have been proven to be either useful or not useful. We span all the way back to, studying Massachusetts business trusts, studying common law contract trusts, things that we have since seen have been pierced by one reason or another. And oftentimes it has to do with how those items are being used. So what we've developed is we've developed some scenarios that have been used in the past by other individuals and have privately been passed on from person to person. And we dissect the security agreements between the entities, the liens that are placed, the amounts that the liens are placed for, and we give a direct scenario in, I guess you would say, in kind of a fantastical sense, I would say, so that it can be applied in real life in many different circumstances, because we're not here to give a specific how-to. We never have been. We're looking to develop and explain and dissect scenarios of different maps that have been created by way of creating relationships between the master trust and, let's say, for example, a holding trust, wherein that holding trust needs to have some form of operating funds, so it develops a loan and loans from the master trust, developing a security agreement, holding whatever property the holding trust owns as collateral for the debt that has been borrowed from the master trust. So what we have now is we have, by control, we have ownership by control, okay? We don't have specific interest ownership. We have control by way of lien rights. So we have a right to ownership. It's a big difference. Now that holding trust,
Can you explain a little bit about that difference before going
the difference between ownership and right to ownership is, let's put it this way. Okay, you own a piece of property for a moment. You then place that piece of property as collateral for a debt that you're borrowing. Okay, let's say you needed $5 and so you're going to give your watch to somebody until they get that until they get that $5 back. Do they own that watch? Do they have ownership of that watch? Do they have an interest, a direct interest in the ownership of that watch? Or do they have a... Well, go ahead.
Go ahead. No. I thought you were asking. I mean, they're obviously in possession of it, so they have some kind of interest in it.
Well, they're in possession of it, right? So they have a possession of it, and they have a possession by way of a security agreement to hold the property as collateral. But do they actually own the property, or would they have to give that property back if they got their $5 back?
That's the agreement to give it back.
They have a right to possession, they have a right to ownership, but they don't necessarily own it. And possession, though it's 9/10 of the law, may not necessarily be the end-all, be-all of that contract. So, a right to ownership is somewhat more like a security interest. It's an interest, but it's a right to ownership, in my understanding. And I can tell you what, Zach will tell you something totally different than what I said, but it'll be similar. So
okay.
He'll explain it a lot better. But just so we understand that when you have a lien right, it is a right to levy. It is a right to liquidate that property and receive what you have. It's not a right to just own the property. You don't just own it. But you have certain rights to ownership and certain rights to liquidation. And, if you want to understand that better, I suggest spending a lot of time in the Uniform Commercial Code. I may have said a couple things just right now. Don't quote me on all of those things because I've been out of the code for a little while. We've been focusing on other things. So,
okay, but
just to, understand.
The point is getting across, though.
Yeah, is that now that trust does not own that holding trust because the holding trust owes the master trust money. It has right to liquidate its property to receive its debt that it's owed to him. So it has the right, if that holding trust defaults and doesn't continue to make payments or doesn't live up to its circumstances, then that trust would then have a right to dispose of whatever property to make up for whatever debt they have with that trust. So that holding trust, however, may actually need to there may be real property that is that is wanting to be acquired here. Well, holding real property in a holding trust is possible, but it's even better to perhaps hold it in an LLC and to have that holding trust own that LLC. So now there's a separation of power or a separation of ownership between the public company that exists in the public owning property, the individual that created, which is the holding trust, that LLC, and the private contract that exists between the master trust and the holding trust to allow that holding trust to even operate because it had no funds to operate from the beginning. So it needed to have a loan just to operate. And then the funds that come from that holding trust probably are used to operate that LLC, to maintain property, to pay property taxes, all of that stuff. All the property taxes are in the name of the LLC. The property is in the name of the LLC. The LLC borrows money from the holding trust, so there is a security agreement between the holding trust and the LLC. So the holding trust has an arm's length distance, but a right to ownership or a right to lien and levy over the property that the LLC has. So what you see is this distinct relationship between three entities, and what you have is a master trust controlling a piece of property in the public without ever touching it and being separated by two entities.
Beautiful
and these things exist throughout law legitimately all the time. This is a legal thing that exists. We're not creating something to avoid taxation. We're not creating something to avoid liability. These things are created like this all the time. And when you study corporate structures, business structures, and financial tax structures, you'll see very similar aspects of what we're talking about. What we're creating is some scenarios, some I guess you would say some hypotheses as to how these relationships would exist. Because, we don't recommend you do anything we tell you to do.
Smart thing to say. One question in all of that, and that was nicely explained, and definitely have to go back and listen to that piece again. But you said that the holding trust has to have a loan just to operate. So where does the loan come from? Where is it borrowing the funds from, that holding trust? Is it like a public entity? Or
the private security agreement, you would need to borrow those funds from somebody. So where would you want to borrow them from? Well, if it was me and I was the trustee of a master trust, looking to accumulate wealth in my master trust, I would hope that I could loan to that holding trust who's trying to manage some property and maybe see if there's a way that I can get a security interest on that property to, to build my wealth of my assets. So why wouldn't they just borrow from the master trust what they need to operate by way of a security agreement and place whatever property the holding trust has as collateral for that security agreement?
Okay. Hadn't thought of that, but sounds like a logical move.
Well, the master trust has the ability to do anything it wishes with its assets. It has the ability to create bonds, to create promissory notes, to do all of those wonderful things.
Okay.
And so if you fully understand the power of the master trust, then you would understand that that is the best bank you could ever have.
Okay. All right. Christian, can you expound upon this, please?
These are somewhat complex concepts if you don't already have a good understanding in trust law sufficient to create a private express trust, to create the master trust that we're then looking to connect out into the public through the trust web. Because of that, we have a new member special offer that we put together to bring everyone in the right way into this information. And we believe strongly that our private trust education course of webinars is the place to start with us. And so what we've done for your listeners and for any new members to GTEN is we've packaged our upcoming live series with the recorded series Private Trust Education, because really, what we're talking about today in the trust web structures builds upon that. And so now, basically, if you register for at gten.org for Private Trust Education, which is the recorded series, it's like 20-something hours of recorded videos, webinars, and reading materials and documents, and it shows you how to set up private express trust. It gives you a sample trust, indenture, all of that. If you register for that course, then we enroll you for free in the current live series that starts July 10, which is Trust Web Structures. So I'm listening to PJ, struggle with trying to explain as much as possible in layman terms what these trust webs do.
Yeah, it's very difficult.
It occurs to me that it's not that. It's not that it's terribly difficult material, but it's hard to do it when there isn't a basic understanding of the private express trust to begin with.
Yes.
All right. So would you guys like to maybe just touch on that for a few moments, just to give people a foundation who maybe didn't hear the show last time,
Yeah, this is kind of how I opened up this conversation. The private express trust series really tackles the understanding of how to create a private contract outside of the jurisdiction of any foreign government. And it's a private contract between individuals placing one person in control of property for the benefit of another. That's the definition of a trust in its purest form, is one individual placing property in the control of another for the benefit of a third. We break all of that down. We break down equity, trust law, all different forms of law and jurisdictions so that you can understand where you're operating from. Then we break down how to administrate and operate as a trustee and operate as a natural person and operate as a representation of a private trust in the public. This starts to add on to that a little bit. The biggest request we got from individuals in our private trust education series is, okay, I get how it is. Now I understand that if I do this, the trust is no longer valuable. If I get a bank account, it's just like any other alter ego. If I get this, it's just like any other alter ego. How am I supposed to use this frickin' thing you told me that is so powerful and is supposed to be separate from all of these jurisdictions?
What can I do with it, right?
There's no such thing as magic paper. We all know that. The paperwork isn't what keeps you out of trouble. It's your actions that keep you out of trouble. So we wanted to expound upon the knowledge of the trustee by allowing them to understand how to operate within the public by creating a series of security agreements, which, by the way, we break down what a security agreement is, how to lien the person or any property that the person has, and how to operate and use those security agreements to create the security agreement, to create the UCC-1 financing statement that shows lien right, and to file all that either privately or publicly, whichever goes where. We break all of that down. We explain the differences of the secured party creditor versus the sovereign versus the trustee, and we break down clearly that the private express trust is the key vehicle or the key vessel, if you're in Admiralty, to operate privately and still interact. But once you've interacted as a trustee with that trust, you may very well have, unless you are privately contracting with those entities, you may have availed yourself to a jurisdiction. So everybody wanted to know how we interact with the public. Well, there needs to be a pass-through entity. An entity that is kind of private, kind of public. An entity that you can see in the public, but there are private aspects to it. That is the purpose of, just for example, in one example, the holding trust. The holding trust operates as an interface. Okay, it operates between the private interface and the public interface. The public interface, for example, would be your LLC. Your LLC is going to do all the things in the public it needs to do. It's chartered by the state, for example, of California. It follows all the rules of the state of California. It pays its dues every year. It pays its taxes. It owns property. It does everything it needs to do in the public. You have this entity now doing it. Well, how do we control that entity? Well, this LLC was created by either one partner or more than one partner, one of those partners being, for example, the holding trust. That holding trust has created this LLC so that it can do business in the public, i.e., purchase a piece of property. In order to do all of these things, it needed to have funds from the get-go, which means there needs to be a private agreement between the trustee of the holding trust and the trustee of the master trust to acquire some funds for this holding trust to do what it needs to do to interact and control that public entity. Okay, now I'm not talking about different forms of income. There's a lot of things that I'm leaving out of this circumstance that you're going to need to put into your own scenario. For example, that LLC may be purchasing a piece of property that's going to bring in an income. There's going to be taxes to handle and all that. I'm not tackling that right now. We're just talking about the relationships between the entities. And that is what we're going to be dissecting. We're not going to be getting into how taxes are operating, how funds are being transferred, how they get paid back, other than the distinctions and the details of the security agreements and liens that exist between these entities. They are going to be example scenarios. For example, holding trust A borrows $5,000 from Master Trust A to operate expenses for paying off, escrow expenses and any kind of purchase expenses for acquiring this property. Okay? Mm-hmm. There is now a debt that exists between the holding trust and the master trust. So the master trust now has a lien right against the holding trust and can liquidate any property that holding trust owns. Well, if the holding trust owns an LLC, then they have the right to liquidate that LLC if necessary. And that is your distinct relationships between them. But you're not fully going to understand that until you have tackled what the private express trust is, because the holding trust is very easy to read and understand. You can do a little research. It's just another vehicle, a special purpose vehicle in the public. An LLC is the same thing. If you want to know, these are some of the things that we covered in private trust education. We cover what a holding trust is, what a nominee trust is, what a blind trust is. These are trusts that are used either under common law or under statutory law. They can exist, they can be recorded, they cannot be recorded. They're very malleable special purpose vehicles. And there are many more like them that are used for this purpose. Social welfare organizations, some of those. Our exempt organizations series covers the exempt format of the public structures. So now that we have defined all of our exempt organizations, a fair amount of our for-profit organizations, which are it's kind of a given. You know what's out there. If you're in any form of corporate law or you've studied at all how to create a corporation or a business, you know what those are. And now we've tackled the interacting interfaces of those trusts, the holding trust, the nominee. Now that we have defined all of those entities, now we've created a series that shows how those entities relate to each other, how they form contracts with each other, and how they would operate consistently in public. Not only that, but we're also going to be tackling some of the other entities that we've covered, such as some of the apostolic organizations that we've covered, such as the 501d, the corporation sole, the private church, all of these things that we just covered in exempt organizations. So this is kind of the put it all together and see how it works series. And we feel that it is an integral part of our private trust education series, but one really can't be had without the other. So we've determined that we need people to be enrolled in private trust education to even really understand the trust web structures and really get that advanced knowledge. So like Christian said, if you go to our website, GTEN.org, and you go to our offerings page, you'll see in there that we have offered for new members to sign up at the normal cost or the normal donation rate of our private trust education series. We will give no additional donation access to our trust web structure series for free. And I think it's very valuable that you receive both of these at once, because this really is the connector. These are the ones that show how we connect everything together. So
yeah, really important, because then the next step is, I have this master trust and I want to keep it private, but what do I do with this thing? And so it seems the webinars that followed came out of that sort of demand, in a way, from I don't mean demand like somebody's stomping, but just there was a demand for it now.
It very much was a
want
demand.
To know what to do with it. Yeah, so it's a very all-encompassing education, and really prepares someone very, very well to go do whatever they choose to do.
Right.
Yeah, Christian.
Hi.
Hi.
Yeah, it's one of 5 parts, okay? And actually what we were just talking about in this special is 2 of 5 parts. We've designed the curriculum at GTEN.org to have 5 key components. We started with the private trust, and that's the private trust education course. We did rights to travel because the understanding of rights is so important, and travel is a place where you can sort of practice that without too big of without encountering too big of a problem. We're talking about infractions for the most part, and so if you want to practice your rights, doing it on the road is not a bad way to go. Then, exempt organizations is the public side. That's operating charities and not nonprofit organizations and such. The trust web structures it kind of connects everything. And the last one we're going to do in the fall is about private banking and lawful money. That one's called Living Free, the system. That'll start in September, and it is, it's how to bank. It's how to operate without drawing your trust into federal jurisdiction. How to avoid, the pitfalls of Federal Reserve notes and utilizing the military script of our of the U.S. corporation. So the five distinct parts all work together in harmony. And I think what's cool about trust web structures coming up is that it has a direct partner in private trust education, as well as a piece of the wheel of 5 subjects, right? So you could definitely do well to start with the 2 of them, and then pick up the others as we go.
Yeah. The others are just as integral, but somewhat auxiliary in where these 2 are going to be the core principle of understanding how to set up and operate limit liability, become judgment proof, and really take full responsibility and empowerment over your life and your estate. And that's something I think all of us have been trying to do.
I believe that's the underlying intention of everybody who's, ever tried anything or, is learning in whatever way they are. It's the same underlying desire to be free. So since we're almost at the end, I think it is a good thing to touch on some of the distinctions between sovereign, secured party, creditor, this term, and trustee of the private trust. So really quick, your opinions on that, because it is important, because there's these different schools of thought and different schools of, actions that can be taken and tried and explored, and success sometimes not. So just quickly, what are both of your, ideas about that?
I'll take this first, I guess. To me, the word sovereignty, it's so deep. To try and claim something like that in the public, you really need a lot. You need your own army, you need your own land, you need your own fort, your own military to represent sovereignty. And then you're going to need to have your own treaties to ensure that someone's not going to usurp your property like many do. So there's sovereignty. The secured party creditor, we cover a little bit of that on YouTube. We cover a little aspect of that and talking about it. And I think it really boils down to the fact that there's such a thing as a secured party. There's such a thing as a creditor. I think that those being used in context of this movement are a little misguided. And that's my personal opinion. And I feel that once you, similar to the term sovereign.
Wouldn't it be a little redundant in a way, right? Like
it's a bit redundant.
The same thing. Yeah.
I believe it's a bit redundant, but I believe it's a little bit misguiding. And I think that the quote-unquote creditor movement was more or less a spiritual movement in understanding that being a creditor is someone who understands that they form the fundamental basis of where energy is transferred. They create the energy, and where you put your energy is what you're going to get in return. And so when you credit something, you become the creditor, right? The individual that creates, the creator. Then you have a responsibility to handle your creations responsibly and to take responsibility and accept what has happened with your creations. So I think that there was something that had to do with a higher spiritual sense of using that term in the, for example, the creditors in commerce movement. With the sovereign citizen movement, I mean, that's just an oxymoron. I mean, this is absolutely ridiculous. And just look those two words up and please don't ever frickin' say them together again.
Right.
As far as the secured party creditor, I think that has a lot to do, once again, with the concept of regaining control over the estate. I believe there's 1,000 ways to skin a cat. And regaining control of the estate is fully understanding the estate, fully understanding, once again, what you have created, what contracts you are in, the invisible contracts that exist, whether tangible or intangible. So becoming a secured party or a creditor was, to me, kind of a proxy for becoming a responsible party of your own actions. Some of the mechanisms that were used in that movement, I believe, are misguided and misunderstood, and I believe they should be very well thought out and very well executed before attempting to do some of the things that have been told during those movements. And I think the major thing that distinguishes, once again, us from the individuals teaching those different movements is that we teach to be a trustee, and that is well rooted in English common law, English trust law, and equity, in understanding that trustees under common law have certain rights and certain powers that supersede that of any chartered entity, or supersede that of any capacity that could be used in a commercial sense, such as a secured party creditor under the Uniform Commercial Code, or a sovereign citizen, which is supposedly this power that is divine. The trustee is somebody that has been given authorization and power by a grantor, meaning that it is not their power that they are attempting to use, but rather have been authorized and have a duty to use, meaning that it is by contract that they are operating, and it is by private contract. So there is a founded principle as to the rights and actions that you're taking as a trustee, as opposed to, say, just claiming you're a sovereign citizen or just claiming you're a secured party when you don't have a security agreement that shows real collateral being held, and you're not in the court representing the collateral. See, a lot of people misuse that secured party creditor thing because they're attempting to lien the person. The person can't be liened, but the property that the person owns can. And so there's a distinction there, and I'm not going to get into that because we don't have a lot of time, but you guys, do your due diligence in that. Understand that you can't lien a person, you can't lien a trust, a beneficiary trust, but you can definitely lien assets. So there's a difference, okay? Once again, I can't get into that. So
yeah. Well, and let's again, because we're just being pressed for time. I mean, I'd like to get Christian, your view on that also, as far as those distinctions and your opinions about that.
I think I can do that pretty quickly. I am sovereign because there's nothing between me and my God. Okay, and there's no government between me and my God. So I am sovereign, and I know that, and I operate that way. And I am the creditor because through my intention, I manifest and create money into the system and create as the hand of the creator. And therefore, the banks aren't the creditors. They're borrowing my instruments. They're the debtors, and I'm the creditor. But when it comes down to where do I want to stand to operate in this current paradigm of commerce and law that we have? Mm-hmm. I'd much rather be operating as a trustee of a private express trust than trying to stand in either of those other roles and convince anyone of anything.
And so, why? And why is that?
The way I see private express trusts right now is that they're the best vehicle that can play with the current system. I believe that we're in a position now where we need to be building a new paradigm. We need to be building a bridge to a new way of thinking and living and a new economy. I don't think our current economy is going to last. I think we're in a fair amount of trouble.
Thank you. Okay, you're saying we need a paradigm shift. Absolutely. Please continue.
Yeah, I believe that. Well, and I'm also personally involved in some projects that will help to parallel the current systems and build a bridge to a new paradigm. And we're actively working on funding some really amazing projects. But until these things get built, right? The best that we can do is firm up the foundation from the paradigm we're in, okay? Because a bridge to a new paradigm is going to require two ends to it, a foundation at each end, right? And we're working on the foundations at both ends. And the firmest foundation that I can get in the existing paradigm is a private express trust. That's one that has been proven to work for the banking elite for centuries, and it's not going anywhere fast because all the laws that they would love to change, trust law is not on their agenda because it's actually used by those banking elite that are so interested in paying for the passing of all sorts of statute and code.
Right,
so
right.
They're not changing any laws on trust law.
And
right,
so in a way, go ahead.
If you're at the receiving end of that, if you're operating under the statute and code, these guys are paying for, through lobbying and greasing palms, they're paying for more and more and more and more control through legislation. Okay, mm-hmm. But if you learn to play the game the way they know it's meant to be played, you can stand on your rights on a private express trust, and you can operate without being subject to all of that control. And that's what you need to do, I believe, if you're going to affect any significant change on this planet. If you're going to take the current problems and turn them into equal and opposite opportunities, if you're going to be able to act on what is available to us today in terms of resources and develop things for a new paradigm and contribute to a sustainable evolution of humanity, a sustainable future for this planet, then I think what we're talking about is, what's the best foothold we can get in the existing paradigm, and that's a private express trust, because they built that for themselves.
Right. Yeah, you're right.
Well,
maybe secured party creditor and the sovereignty movement in a way is trying to reinvent the wheel, but really, at the end of it all, we don't need to. Right? We can just utilize what these.
I just think it meets with a lot more resistance trying to take one of those routes than.
Okay, you know what, guys? I have a caller who's really, really, really wanting to ask a question. So, caller, are you with us? And let's take the question quickly and give them time to respond. So, Go ahead, caller. What's your question?
How you doing? This is Rick from Shake and Wake, and we have Tammy on every Monday. But I wanted to ask what they thought. I'm getting into this sovereign thing. I'm going to fill out all the papers, and Tammy's one of my teachers. What I wanted to know is, what about if I'm not going to have a license or something like that, how about like for cashing checks, or if you need ID, like at the liquor store, how does that work, in your opinion? I mean, I can ask Tammy, but I want to hear your opinion also.
All right, so each of you take like 30 seconds and just give your opinion. Thanks for the call, Rick. I appreciate it.
All right.
Okay, go ahead.
Well, if you could picture the state as a trust and it issuing its own trust identification, then wouldn't you be able to see in the same light a private express trust being able to issue its own identification?
Question?
And the driver's license is such a loaded form of identification. It comes with a whole contract that I don't want, so I don't use it. A passport or a foreign ID of some sort. I mean, there's all kinds of ways of getting identification that don't have all the contract of the driver's license.
Yeah, you only need a family Bible to get a passport, and a family Bible is the exception to the hearsay rule. So, you can.
What about like you said, like at a liquor store or something? Let's say you're going to get a bottle of wine, and the person actually wants to wants some identification from you to see if you're of age. Let's play a game.
Well, this is the whole thing. Okay. Well, for example, I don't bank, but we have to pay bills. Oftentimes, we have a lot of things. So I have an authorized representative that handles things on my behalf, and I have private contract between that person. So I don't worry about that stuff. I don't show my ID. I don't. If I'm doing really well and I'm wealthy, I got somebody else handling that stuff for me. So we're looking about how these individuals operate. Does Nathan Rothschild walk into a liquor store and buy himself a drink?
Probably not.
Or does he concern himself more with controlling the funds of a nation and not the laws of one?
Right. Okay.
So it's about where we're operating from, and it's about the level at which we're operating from. So, yes, you're going to run into those issues immediately, and I'm not going to have a direct answer for you because there's a good chance that unless you don't know that liquor store clerk very well and you haven't had a 5-minute conversation with him, you may end up having a little bit of issue. And then again, you may be savvy enough to do what's necessary to get what you need. So there's going to take a certain level of savvy, a certain level of shrewdness, and a certain form of creative reconditioning in your life to assess those situations, because you are going to be operating differently, and most people don't recognize that. So it's a very good question to bring up.
Yeah. Reconditioning. Good point. Because, totally retraining ourselves in our thinking and our responses and how we handle ourselves. And it is a bit higher level of responsibility, but one that I feel is the time to step into. I do indeed feel that this is our only ticket to living freely. Is the more responsible we become, the more free we can live these lives.
You hit your friend up who you haven't told about this sovereignty game, and you tell him, hey, man, can you roll to the liquor store and grab me a 6-pack? So then you don't have to use your license, you don't have to drive your car, you don't have to use your ID, you don't have to use Federal Reserve notes. All you got to do is say, hey, I'll pay you a little later. You just contracted privately in trust with a promissory note to receive what you needed in your life. So it's about reconditioning your thought process and understanding and deconstructing the everyday relationships that you have and every action that you take in your life. And that's what it's going to take for you to properly operate. And it's far greater than filling out some sovereignty paperwork. Trust me on that.
Right. Well, thank you, everybody, for joining us. Thank you, Christian. Thank you, PJ. You guys are amazing. Everybody, thank you for tuning into the Humanity Transcending Show and Revolution Radio at freedomslips.com. I'll be with you next week. Everybody have an amazing week.